Okay, good morning, everyone. We're here on Monday morning civil docket. I hope y'all had a great weekend. And let's go ahead and get started with quick announcements. Attorney Dan Mora.
Good morning, Judge.
Good morning, sir.
I've got F 4689-29-20-9.
Okay, do you know what number that is on the court's docket?
Judge, I don't know if for some reason, I got the Zoom information for Mr. Guarena, but I know we had, it's an entry of judgment, I think is what it is, on the divorce. And I just got off the phone with Ms. Aguilar.
Oh, okay, so it's on that divorce with the older couple?
Yes, ma'am. I did speak with everyone. We're just asking the court to go ahead and sign it. And I did speak with Ms. Aguilar about 15 minutes ago with regards to that.
Oh, okay, I don't see it on my docket. Give me the cause number again.
It is F 4689-20-9.
Okay, so has that decree already then been filed?
I believe it. If it hasn't, Ms. Aguilar was going to be filing it this morning, Judge.
Okay, so then you're asking for whenever it is filed that it be forwarded to my queue and I sign off on it.
Yes, ma'am.
Okay.
That's it.
Yeah, no problem.
May I be excused?
You certainly may.
Thank you.
Okay, thank you. Attorney Armando Guerra.
Yes, Robert, good morning. I'm here on number one in your civil docket.
Okay, that's F 0362-20-9 in the matter of the marriage of Angel Rocha and Nancy Longoria. What is your announcement, counselor?
Your Honor, we're just, I need some more time. Actually, Mr. Villalobos, who's the opposing counsel, he's, I believe he's out on vacation. So if you could just give us, Judge, if possible, 2 weeks, a 2-week reset, if the court's available.
Okay, is this already ready? Like, have y'all already reached an agreement?
There's really minimal issues, Judge, with the child support and all that, and custody is not an issue. So, and I don't think there's any community property. So it would be something that we could wrap up rather quickly. But if the court can't give me 2 weeks, if they could, 30 days would be better, Judge.
Okay, well, how about the 20th, or you need later than the 20th?
The 20th is fine, Judge.
Okay.
September 20th?
And September 20th at 9:30.
9:30. Thank you, Your Honor. I have nothing further. May I be excused?
You certainly may.
Thank you.
Okay, Attorney Graciela Orellana.
Good morning, Your Honor. I have two on your civil docket this morning, number 33.
Okay, that is CL 171821-I Maximino, Maximino Vega versus Vanessa Reyes. And what is your announcement?
On this one, Your Honor, I'm not sure who's the opposing counsel since Mr. Hernandez is no longer with Allstate.
Good morning, Your
Mr.
Honor.
Guerra,
Michael Guerra here for Defendant Reyes.
Okay,
Perfect. On this one, we're just needing a trial date, Your Honor.
We filed a motion for a DCC back on the 10th of this month, Your Honor.
okay, so where are we then? Are you completed with your discovery process?
Yes, Your Honor, this is an old case. It was filed back in 2017. So we've completed everything, mediation, discovery, and all that good stuff. So yeah, we're just needing a trial date.
When did y'all
Correct,
go
Your
to
Honor.
mediation?
2018, I believe, Your Honor.
July of 2018.
And y'all were too far apart?
On this one, yes, Your Honor.
Okay. And are you requesting a jury trial or a bench trial?
Jury trial.
Okay. And then let me have you come back on February the 7th, and I'm hoping by then we have a better picture of how we will be conducting our trial docket, or when we will be conducting our trial docket. So it'll be February the 7th at 9:30.
For a status hearing, Your Honor?
Yes, yes. I know you're gonna make the same announcement, but at that time I should be better prepared to give you some dates.
And February 7th, Your Honor?
Yes.
Thank you. That concludes my business before this honorable court. May be excused.
Okay. Hold on. I think he got off. Gracie, we didn't realize that that was the day that we're blocked off on that day. It would actually be on the 9th. Sorry about that. If you can tell Michael, please.
Of course, Judge, I'll go ahead and send them an email shortly.
Okay, it'll be February 9th at 9:30.
Okay,
All right?
yes, and the other one I have is number 36.
Okay, CO 1945889-I, Carmen Viera, Viera et al. Versus TNT Crane and Rigging Inc. et al. And what is your announcement?
On this one, Your Honor, I believe I saw Ms. Oliveira online just a minute ago.
I'm here. I'm here.
Okay, and what is your announcement?
And there is one more attorney that should be here.
Your Honor,
Brianne Richardson, too.
I'm here, Your Honor. It's Brianne Richardson for TNT Crane and Rigging.
Okay,
Just wanted to make sure everybody was here, Your Honor. We have mediation set for November 4th on this one.
with who?
Oh, I didn't write it down.
It's Scott McLean, Your Honor.
Okay.
Okay. And how about your depots and the rest of the discovery process? How are y'all doing on that?
I think it's pretty much complete, Your Honor. If we don't get it settled in mediation, we might need some expert depots to be conducted.
Okay, then let's go ahead and come back on November the 17th at 9:30, and you can give me a status at that time.
Okay, Judge.
Okay, anything else?
Thank you, Honor.
I have nothing further, Your Honor. May I be excused?
That's it.
Yes, ma'am.
Have a good day.
Okay, you too.
Thank you.
Okay, Attorney Jose Caso?
Good morning, Your Honor. This is a prove up for an uncontested divorce.
Okay, and does Mr. Gonzalez have representation?
No, Your Honor, I think it's I don't believe that that he filed an appearance. We provided him with multiple notices.
Okay, so then it'll be a default
A
divorce?
default- Yes, Your Honor.
Okay,
And I've got my client with me. We can just put this real quick.
okay.
Morning, Your Honor.
Good morning. Okay, let me call F 4279-20-9 in the matter of the marriage of Daniela Gonzalez and Juan Cantu Gonzalez. Can you please raise your right hand? Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God, ma'am?
I do.
Okay, Mr. Caso, you can proceed.
Thank you, Your Honor. What is your full name?
Daniela Gonzalez.
And before filing this petition for divorce, have you lived in Hidalgo County for at least 90 days and the state of Texas for at least 6 months?
Yes.
And is it possible for you and your spouse to stay together?
No.
Have you had a chance to talk to your husband about these proceedings?
Yes.
And what did he tell you?
He was non-responsive. He told me we'll talk later. There was just never a chance.
But essentially, you've asked him, you've told him multiple times about these proceedings,
Yes.
and he's chosen not to participate.
I gave him the papers and I told him a lot of times and he didn't show up.
And that's in addition to him being served by a court process server.
Yes.
Okay. And have there been any children born or adopted during the marriage under the age of 18?
Yes.
Okay. And you're asking the court to set a child support payment of $650?
Yes.
Okay. And are you expecting a child at this time?
No.
And have you had children with anyone else during this marriage?
No.
Are you asking the judge to let you keep whatever you have and your husband keep whatever he has?
Yes.
Okay. Is there anything else you want to tell the court?
Well, yes, Your Honor. I just want to say that I know he has a lot of resources. He has a lot of money. His dad, he's a very wealthy man. He's choosing not to support his own child. It's just, I don't know if he doesn't care or if he doesn't think it's important, but yeah, sometimes we struggle. I mean, my daughter has expenses. She's 14. And I have asked him a lot of times to just take care of her. and sometimes he hands me over $200, 300 tops, and I think that's just not good enough.
And are you asking the judge to grant the divorce?
Yes, please.
Nothing further, Your Honor.
Okay, and what does Mr. Gonzalez do? Is he employed with a company or is he self-employed?
Yes, he's employed.
I'm sorry?
Yes, he's employed.
Okay, who is he employed with?
At the time, I don't know. I think he works in Reynosa.
So what are we basing the calculation for the child support on?
He works here in Reynosa, and he files taxes. He has income.
Okay, so I understand that, but in order for me to order the $650 for child support, I need to know what you are basing it on. So Mr. Castle, have you seen past income tax returns? Or are you estimating that for his profession, that's more or less what he earns, or what are we basing it on?
Yes, Your Honor, we had some estimates, and I don't have them right in front of me, but we did arrive at that number based on what we believe he earns. He drives very nice cars, and you can see him out in very nice restaurants on any given weekend here in the Valley. And we know he works for his dad, so a lot of times it's hard to know specifically how much he's earning, just because of and his dad owns a lot of companies, both here and in Monterrey, Mexico, and in Reynosa, manufacturing companies. So extremely successful.
Okay, and I'm looking at your order setting hearing and it was only copied to you. Was he aware of today's hearing?
Yes, Your Honor. My client spoke to him multiple times. I mean, she's tried to get him to participate in the process, and he's choosing not to.
Okay, and so how are you going to collect the child support? Like, are you just gonna, because you're not gonna be able to do a withholding order, or are you?
No, Your Honor, we're not. So we're just hopeful that once the order is rendered, we can either file a motion to enforce, or maybe the AG's office can, lend some assistance. But this is where we're at now. We really don't have any other way of going about it. And I don't know if Your Honor remembers, but we had to serve him through, posting by citation by posting, just because he chose to always, kind of
Yeah.
hide. We would call him, or we would know that he was at a certain restaurant and he would see us coming and head out and things of that nature. But again, we just have, if you go to La Fogata or, some of these nice
Okay.
restaurants, he's there.
Okay, and then let me see. And did you establish that he'll be receiving a standard visitation? I know the child is 14, so.
Yes, and pretty much so far it's been, that whenever he wants to see the child, he's allowed. We're giving standard visitation in the order, but we would hope that he would come visit the child every weekend or every other weekend, but he just it's very sporadic, maybe once every couple months.
Okay, and what about retroactive support?
So Your Honor, we're really not requesting it at this time. We just don't think it's going to be successful. I think my client just wants a divorce more for the purposes of getting divorced than for having any realistic expectation of recovery.
Okay,
The child's 14 and it's already been, they've been together on and off, and so it's also hard to track when they've been together and when they haven't. So I think for, realistically, the child's 14, there's 4 years left, and if he could help out something, and that would be probably the best we can expect.
okay, then the court will take judicial notice of the filings in the court's file and will approve the terms of the divorce decree that'll be set forth in further detail in a final decree of divorce. When do you expect to submit that by, Mr. Castle?
We'll file it right now, Your Honor, by today.
Okay, all right. Okay, well, Ms. Gonzalez, were you requesting a name change?
No, Your Honor.
Okay, all right, well, best of luck to you, ma'am.
Thank you.
Okay, have a good day.
Thank you, Your Honor. Nothing further.
Okay, thank you. Attorney Damian Orozco?
Good morning, Your Honor. I'm here on number 23 on your civil docket. That's on F 282769, Your Honor. And this is a case now in your court. There's a case at a County Court 5 in F 6118-185. That's the OAG's number and case, Your Honor. And this is a motion to consolidate that case into your case, which is a divorce case, Your Honor.
Good morning, Your Honor. Ricardo Lanís on behalf of Mr. Juan Manuel Garcia, Your Honor.
And
I
you
also-
with the Office of the Attorney General.
And Judge, we're not opposed to the motion to consolidate. I apologize for not wearing a tie. I'm on vacation right now in New Mexico. So it's good to see you, Your Honor.
Okay. Likewise, Mr. Alcantara, any opposition?
No, Your Honor, I believe this is our motion as well.
Okay. Okay, being no opposition, then the court will grant the motion to consolidate. Is there an order on file?
I don't believe so, Your Honor. The Office of the Attorney General can prepare it and have it submitted.
Okay, just go ahead and prepare it and have it submitted. And just for the sake of efficiency on this one, everyone doesn't have to sign off on it because we don't want to interrupt Mr. Alanis's vacation any further. Okay.
Thank you very much, Your Honor. Thank you.
Okay, so just go ahead and get that forwarded to me and we'll go ahead and get it signed off, okay?
Thank you, Judge. That concludes my business. May I be excused?
Yes, you may.
Have a
Thank
great
you,
day,
Your Honor.
Judge. Stay safe.
Okay,
Thank you, Your Honor.
likewise, likewise.
Thank you, Your Honor.
Okay, Miriam Moreno?
Hello, Your Honor.
Yes, ma'am.
I was just have the name change hearing.
Okay,
So
do you
I think
recall? Let me see. Do you know what number you are on the docket?
29.
Okay. And you're representing yourself this morning?
Yes, ma'am.
Okay, that's F 4700-20-9 in regard to Miriam Eileen Moreno. I think we were just pending your DPS report. Is that correct?
Yes.
Okay, let me just check the file. Okay. All right, Ms. Moreno, please raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God, ma'am?
Yes.
Okay, the court will take judicial notice of all the documents in the court's file, specifically a criminal history report that was received and accepted by the clerk's office on July 13, 2021, showing that Ms. Moreno has a clear record. Ms. Moreno, this morning you are here before the court on your pro se petition to change your name. Is that correct?
Yes.
Okay, so currently your name is Miriam Eileen Moreno. Is that correct, ma'am?
Yes.
And Ms. Moreno, you are asking for your name to be changed to Miriam Eileen Teran. Is that correct?
Yes.
And that is capital T-E-R-A-N. Is that correct?
Yes.
Okay. And this is because you no longer wish to carry the surname of your biological father. Is that correct?
Yes.
Okay. And Ms. Moreno, are you trying to avoid any criminal prosecution in any case that is pending against you?
No.
Okay. So you are seeking this name change solely based on your personal reasons to no longer carry your father's surname?
Yes.
Okay, ma'am. Then the court will grant your request, and your name will now be changed to Miriam Eileen Teran. And Ms. Teran, I believe, let me see. You do have an order on file that we had returned And I'll go ahead and ask my staff to have that sent back to us so I can review it.
Okay.
And then once that's submitted to me, then I'll sign off on it. So you will need that. And you will need to get that in certified copies. In other words, you will have to come to the courthouse and you will have to ask for certified copies of that so that you can take it to the driver's license entity and for Social Security, okay?
Okay.
And also, you'll need to, I mean, if you're, I don't know how much further you're gonna be taking it, but it's your responsibility to look into what needs to be changed because you're representing yourself, okay?
Yes, ma'am.
Okay, well, congratulations, ma'am, and once that order is signed, you'll be known by that name from that date forward, okay?
Thank you so much.
Okay, so we'll just ask for that. All right,
Yes.
yes, you may.
Thank you.
Okay, Attorney Louis Patino.
Good morning, Your Honor.
Good morning, sir.
Your Honor, I'm here on court stock number 25 in the court docket. This is,
Okay.
Jennifer.
F 3166-21-9 in the matter of the marriage of Jennifer Adame and Ricardo Aviles. And what is your announcement, Counselor?
Your Honor, we filed a motion for a substitute service through posting on this case, Your Honor. My client is unable to locate her husband at this point. It's been since February, and we're asking the court for an order to that effect, Judge.
Can you give me one moment? When is the last time that Miss Adame has had contact? Well, you know what? Let me go ahead and swear her in case I have questions for her.
It's
So, Miss Adame, will you please raise your right hand? It's okay, as best as you can. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, Miss Adame, when's the last time that you had any contact with your husband?
February the 14th.
Okay. And at where, do you know if he's living in Hidalgo County?
No.
Okay. And let me see. And you've had no contact with him then for the previous about 5 to 6 months then?
Mm-hmm. Yes.
Okay. And do you have any contact with your in-laws?
No.
Now, the baby that you have in your arms, that is that baby part of this divorce?
Yes.
Okay. So, Mr. Patino, will you be filing an amended petition?
Yes, Your Honor. The baby was just born
August the 13th.
August 13th, Judge.
Okay, well,
And so I-
congratulations.
I could amend that, Judge.
Okay. It'll need to be amended because then you won't be able to bring up, I mean, well, we can't dispose of it if you don't amend it. So go ahead and amend that as well. And you're asking for this citation to be by publication because you do not know his physical whereabouts. Is that correct?
Yes.
Okay. Mr. Patino, I'm going to grant your motion for substitution of service for citation by publication. I do need for you to submit an order appointing an ad litem for the absent party. And your client will be responsible for the nominal fee for that.
Yes, Judge.
And do you have a order granting on file?
I'm not certain, Judge, but if not, I will take care of it today.
Okay, I do see that an order on that substitution was filed by you on August the 4th. So I'll ask for that to be forwarded to my queue.
Yes, Judge. Thank you.
And then I'm gonna wait for your appointment for the ad litem for the publication also. I'm gonna give you 2 weeks to submit that. So that needs to be submitted by September the 10th. I'm gonna have a ticker on that, okay?
I'll take care of it today, Judge.
Okay. All right, anything further?
Nothing further, Your Honor. Have a
Okay,
great day, Judge.
thank you, likewise.
Thank you.
Yes, okay, Attorney Jaime Bailey.
Yes, good morning, Your Honor. Jaime
Good
Bailey on behalf of the defendant. I'm not sure what the number is on the court's docket, but it's CL 162875. Gilbert Mendoza versus Myra Banda et al.
Good morning, Your Honor. Vanessa Rubio here on behalf of plaintiff. It's number 32 on the docket.
Okay, thank you, Ms. Rubio.
Yes, Your
All
Honor.
right, and what is your announcement?
I'm fairly new to this case, Your Honor, but in looking at over the file, my understanding is that discovery is pretty much complete. If not complete, the case has been mediated. It has been pending for a while and has had previous trial settings. So I think we just need to get it reset for trial sometime next year, I guess.
Okay, so when was mediation conducted?
I'm not sure about that, Your Honor. Like I said, I'm fairly new to the case, but it was completed over a year ago, if I understand correctly.
Ms. Rubio, do your notes indicate when this was mediated?
I believe the mediation was in 2018. From my understanding, the mediation, they weren't close. We were added on in 2019 and Mr. Bailly in 2021. But from my understanding, it wasn't going anywhere in mediation.
Okay, so then were you all, so you all were not part of the mediation process then?
No, Your Honor.
Okay.
As of right now, there are a couple of pending motions that predate both our side as well as when Mr. Bailly joined in. At this time, we would like to speak with Mr. Bailly to see which ones we would like to proceed forward with and which ones we wouldn't at this time. But otherwise, from our end, we only have maybe an expert depot to take closer to trial, but most of the discovery is done on this case.
Okay. Well, if you have those, if you decide that any of those motions need to be heard, just make sure that you file an order setting hearing or an order resetting hearing. I'm not sure if they were once said and then you all passed it or not, so that we can get you a setting date, okay?
Yes, Your Honor.
Assigned judge.
Okay. All right, well, if you're gonna be asking for a trial setting and you're saying that it's pretty much worked up for that, then I'm gonna have you come back on February the 9th at 9:30, at which time hopefully I'll be able to give you a date. And since you are a 2016 case, you'll be getting preference. We're working on a list and we're gonna be going from the oldest to the newest, okay?
Okay, thank you, Your Honor. That's all I have. May we be excused?
You certainly may.
Thank you, Your Honor.
Thank you. Okay, Attorney Janelle Castle.
Good morning, Your Honor. We have number 34 on your docket.
Good morning, okay. CO 19142-I, Danielle Gonzalez versus Michael Birdsong.
Your Honor, I'm representing the defendant, Mr. Birdsong, and I believe Mr. Davis is on. Saw him.
Good morning, Judge. Robert Davis here for Mr. Gonzalez.
Okay, good morning, Mr. Davis. And what is the announcement?
Your Honor, we've mediated this case and discovery is pretty much substantially complete. So we're just waiting to get a trial setting on this one.
That's correct, Judge. We mediated, I believe, in January of 2020. The parties were far off. If the court would give us a trial date at the court's earliest convenience, I think both sides would appreciate that.
Okay, so then we'll return on February the 9th at 9:30, and you all have already heard me, at which time hopefully I'd be able to give you better guidance, okay?
And that's set for a status, Judge?
Yes, it has to be a status.
Okay, thank you very much, Judge. That's all I have before this court may be excused.
You certainly may. Ms. Casso, anything else?
No, Your Honor, may I be excused?
You certainly may.
Thank you.
Okay, Attorney Robert Mesa.
Good morning, Judge.
Good morning, sir.
Judge, we have number 2 on the court civil docket this morning.
Okay, F 0647-13-9, in the interest of minor children.
In
Okay,
this case, Victoria Flores, Your Honor, is representing the petitioner on this case. We were set for 11 o'clock this morning. And I got a text early this morning from her office to see if we would be okay with passing the hearing. She's got another contested hearing according to what I received this morning as well. So I've agreed to pass, considering obviously if the court would allow it. We were set for final. It was going to be for a bench trial. And so Ms. Fuentes, Diana Fuentes Aguilar is the ad litem on the case. And I've also received an email from her, and I've let her know, depending on if the court is agreeing to allow us to pass. I'm in agreement with it. And so that's the announcement, Your Honor. We were set actually for 11 this morning.
okay. Ms. Rivera, can you give me a date for a DCC so we can set the bench trial?
Yes, ma'am. It'll be September the 17th at 2 p.m.
Okay, Mr. Mesa, I'm gonna go ahead and set you up for a DCC for September the 17th at 2 p.m. All parties need to be on so we can reset this matter, okay?
Yes, Your Honor. And I will let the ad litem know, Your Honor, as well as give Ms. Flores a call or send her a text as well, Judge.
Okay,
Okay, that's all we have, Judge. May we be excused, Your Honor?
you certainly may.
Thank you, Judge. Have a great day and be safe.
Likewise, Attorney Robert McLaughlin.
Yes, Your Honor, I have 6 items on the civil docket today.
Okay,
The first one is number 11.
CO 175048-I, Portfolio Recovery Associates versus Rosa Duarte. And
Yes.
go ahead, you're here on a default judgment?
Well, I believe that we need to pass that. I believe that the defendant had filed an answer, so we need to set it for a bench trial.
Okay, Mr. Damian, can you please call out the defendant's name?
Yes, ma'am. I do apologize. What number was that on the docket again?
Number
11.
Thank you. Rosa Duarte. Rosa Duarte. Rosa Duarte.
Okay, go ahead then. You want to file, set this for a bench trial?
I want to set it for a bench trial, and we will file a motion for summary judgment as well.
Okay. If you'll file the motion for summary judgment, make sure that you attach the order setting hearing.
Okay.
And then that way we can go ahead and get that set for you. When do you think you'll be filing that motion for summary judgment?
I will ask that it be filed today. It shouldn't be very hard to get it on file, but no later than the end of the week.
Okay, I'm gonna set a tickler for you to file that summary judgment by September the 10th,
Yes, Your Honor.
because if not, then I'll lose track of the case. So why don't we take it in steps? File
Okay.
your motion for summary judgment first with the order setting hearing, and you'll do that by September the 10th. And then we'll see where that takes us, and if necessary, we'll set it for a bench trial after that, okay?
Thank you, Your Honor.
Okay, what other case do you have?
Number 15.
CL 196425-I, Portfolio Recovery Associates versus Michelle Galavis.
In this case, Your Honor, we'd like to continue the case because we believe that we've reached a settlement with the defendant.
Okay. I'll go ahead and give you, how much time would you need in order to complete the settlement, sir?
I would say 30 days.
Okay. Let's go ahead and reset this status for October the 6th at 9:30 a.m.
Okay.
And then if everything's been filed before then, you don't need to make an appearance or an announcement. But if not, just come back on and let us know what happened.
All right. The next one I have is number 16 on the docket.
CL 200188-I, Con Appliances versus Jacqueline Ramirez.
And we would like to proceed with a default judgment in this case.
Okay, Mr. Damian, please call out the defendant's name 3 times.
Yes, ma'am. Jacqueline Ramirez, Jacqueline Ramirez, Jacqueline Ramirez.
Okay, there being no response, go ahead and you can proceed.
Yes, Your Honor. In this particular case, the defendant had opened up a credit account with Conn's Appliances that they subsequently defaulted on in the amount of $1,587.35. We're seeking damages in that amount. We'd ask the court to take notice of the certificate of last known address, the non-military declaration, and the business records affidavit, which includes the retail installment contract dated June 11th, 2016. And they made their last payment on November 17th of 2017. So we are within the statute of limitations.
Okay, let me just check something here. Okay, the court will take judicial notice of all the pleadings in the court's file, and specifically the return of service, showing that the defendant was served on February the 20th, 2020 at 4:03 p.m. Further, there is not an answer on file, although she was properly served. Okay, the court will grant the relief as requested. Do you have an order on file?
I believe we do, Your Honor, and if not, I will have one e-filed with the court today.
Okay, let me see. You have one on file back from August the 13th, 2020. If that one is correct, we can ask that to be forwarded to us.
I believe that one is correct.
Okay, then I'll ask for my staff to have that forwarded to me.
Okay. The next one I have is number 17.
CL 200658-I, Crown Asset Management LLC versus Oscar Garcia Jr.
In this case, we need to withdraw our motion for default judgment because I believe that they filed an answer, and we would like to file a motion for summary judgment. And if you can set the tickler for September 10th, like you did on docket number 11.
Okay. Then the court will go ahead and I'll just set a tickler for myself on September the 10th to make sure that you filed the motion for summary judgment and the order setting hearing.
Okay.
Okay.
I have number 27 on the docket.
And that is CL 161634-I, Jefferson Capital Systems versus Alejandri Soto.
And we believe that we've reached a settlement and we're waiting on the settlement documents. And I would request to continue the case for 30 days.
Okay, we can go ahead and do October 6th at 9:30.
Yeah. The last one I have on the docket says that it is scheduled for 11 o'clock. And it is a motion for default judgment. Should I just log back in at 11 o'clock?
What number is that?
Number 43.
Okay. Yes, if it's set for 11, then you'll have to come back at that hour. Because or else you won't be able to take a default judgment on them if you do it prior to that time.
All right. I will log back in at 11. That I don't have anything else until that time. May I be excused?
You certainly may. We'll see you soon.
All right. Thank you.
Okay, Attorney Chris Sanchez.
Good morning, Judge.
Good morning, sir.
I'm here on number 38. on your civil docket, on behalf, Chris Sanchez on behalf of Eric De Leon. Judge, this cause has already been non-suited.
Okay, that's CL 23441-I. Okay, I'll make that notation. I think did I sign it already?
Yes, you did, Your Honor.
Okay, and your next case?
And then on number 40, Chris Sanchez on behalf of Sara Adame Najera. I believe opposing counsel Frank Sabo is here as well.
Okay,
Yes, Judge.
that's CL 211790-I. Okay, gentlemen, what's the announcement?
Well, Judge, on this matter, we are still conducting discovery. There's some depositions that need to be taken. And I imagine after we take those depositions, maybe Frank and I and our clients may try to mediate this matter with maybe we'll file a motion to refer to mediation at that point in time. But we're still in the discovery stages.
Okay.
Yeah, Judge, this is a real new case. It filed in like June.
Oh, okay. So that is real new.
Or our answer was filed in June, so it's real new.
Okay. Okay, well, I'll give y'all some time to work up the case. Let me see. When do you think you all would be able to give me a good status just to show some productivity? In December?
December.
Probably not. No.
Okay. Then,
this is at the bottom of a long list. It's really new.
okay, well, let's come back on January the 31st then at 9:30, and I want to know where we're at by that point.
Okay.
Thank you, Your Honor. That's all I had. May I be excused?
Yes, you may.
Yeah, me too. Thank you. Good to see you.
Okay. Likewise. Attorney Mario Palacios?
Hi, good morning, Judge. I have number 39, Judge, CL 20-3900B. Mario Palacios for the defendant, Diva Verastegui. And I believe Selena Padilla is the plaintiff's attorney.
Okay.
Yes, good morning, Your Honor.
Good morning, and what is the announcement?
Judge, we have conducted some discovery. I did take a plaintiff's deposition June of this year. She did identify some treatment that she had received related to our accident. We were attempting to see if we can set up mediation on this one, but there are still records that are missing regarding plaintiff's treatment, both for this accident and prior to this accident for similar type treatment. So, we have just completed some discovery, but we still have a few issues before we go and set up mediation. And so that's where we're at this point, Your Honor.
Okay, Ms. Padilla, do you want to add anything?
No, Your Honor, Mr. Palacios summed it up pretty well.
Okay, so do you have a time frame of when you'll be receiving those missing records?
I'm pretty sure I can work well with Ms. Selena as far as either getting the records or getting an authorization so we can go through the provider themselves directly. And then setting up mediation, Judge, I'd probably say like 60 days, 90 days. I don't see why we don't have that and also schedule mediation and possibly complete it. And so I think 90 days, 60 to 90 days would be fine.
Okay, so do you think you'll be ready to mediate this within 90 days? Or do you want to
I think so.
give me a status in 90 days?
No, I think we should be able to have mediation done by then. I mean, looking at my schedule, I know it's 90 days out, but I don't see why we can't schedule it and or negotiate it. It's not too big of a case damage wise, but I think we can possibly have it mediated within that time frame.
Okay, then I'm going to send you an order of referral to mediation within 90 days, okay?
Sure thing.
Okay, anything else on this case?
No, Your Honor, there's nothing further on this case, and I don't have any other cases at this time with you this morning, Judge.
Okay, let's come back on, let me see. Let's come back on December the 15th, just to let me know if you all did mediate it.
All right, sure thing.
At 9:30.
Thank you, Judge. Having
Okay.
nothing further before this honorable court may be excused.
You certainly may.
Thank you. Have a nice day.
Thank you. Ms. Padilla, do you have anything else?
Yes, Your Honor. I actually have two other items on your docket this morning. I apologize, I do not have the docket numbers for them. But the first one is CL 192467-I, Omar Delgadillo. I believe
That's
that Memo Tijarina is here.
That's 35, Your Honor, on your docket. And Memo Tijerina here on behalf of Mr. Ozuna.
Okay, CL 192467-I. And what is the announcement?
Your Honor, we had a hearing back in May. You had explained to us that obviously with the no jury trials, we're supposed to get a date today. We'd previously mediated this case and it was unsuccessful. So I think we were supposed to get a new trial setting today, but it sounds like based on your other hearings, we're gonna push that back a little bit.
Yes, never. I didn't even, think that we would be in this situation now. I don't know if y'all saw the latest. It's so sad, 8 deaths and over 400 positive cases in our county. And the highest last week was 20 deaths. Absolutely sad situation. So if you're still in that where you are needing a trial setting, then I want to have y'all come back on February the 9th. And hopefully by then we will be able to set you up for trial.
Yes, Your Honor. At 9:30, Your Honor?
Yes, sir.
Your Honor, that's all I have. It sounds like Ms. Padilla has some additional. May I be excused?
You certainly may, sir.
Good to see you, Judge.
Likewise. Okay, CL 191967-I, Juanita Garcia versus Penske Truck Leasing et al.
Yes, Your Honor. This case had defense attorney. I don't believe I saw anyone from their firm. However, they had filed the motion for summary judgment. We filed our response as well as a motion for continuance. However, as of late last week, the parties did arrive at a settlement. So the motion for summary judgment hearing is no longer needed, as well as the motion for continuance.
Okay, so how much time do y'all need to submit the documents?
Your Honor, I believe that we are trying to determine whether or not we will be needing a friendly suit for this case. And so if we could have 60 days to sort through everything, I think that would be the best amount of time.
Okay, October the 27th at 9:30. And then if you need a friendly suit hearing, go ahead and put that date on your order setting hearing.
Okay. Thank you, Your Honor. I have no other business. May I be excused?
You certainly may.
Thank you.
Thank you. Attorney Daniel Longoria?
Yes, Your Honor. I have number 24 on your civil docket.
F 2958-21-9 in regard to Saul Buentea Jr. Go ahead.
Yes, Your Honor. Mr. Saúl Villarreal is present. This is a name change petition.
Okay, let me just check that all the documents are here. Okay, Mr. Longoria, I'm not showing that his criminal history has been filed with the clerk's office.
Okay, Judge. Well,
Usually either DPS sends it directly or it gets filed by the attorney's office with the clerk, and that needs to be on file prior to the hearing taking place. I mean,
Okay, Judge, well, I'll follow up with the clerk on that. I was hoping it would have been filed by now, but I guess.
Do you know if it was the address to the clerk given directly to Austin? Were they sending it directly to the clerk or directly to you?
Your Honor, I'm not too sure. I'll follow up with them. I know, I'll follow up with them, Judge, and then I'll file another order setting hearing once I figure out what's going on.
Yes, once you find out, just go ahead and file an order resetting hearing and we'll get you set.
Thank you, Your Honor. My client is present. May we be excused?
Yes, you may.
Thank you.
Okay. Attorney Lucy Thompson.
Good morning, Your Honor. I'm
Good morning.
here on number 41 on the court's docket.
Okay, F 5108-16-9 in the interest of a minor child.
Yes, Judge, we're set for a status hearing today. I understand that the ad litem, Kathy Alvarado is not feeling well. The only issue I think we have, quote, pending is to give us a final hearing date, one, and number two, she made a recommendation, she being Kathy, Mrs. Alvarado, made a recommendation on the pickup and drop off of the child. And it's my understanding the mother, who's on the Zoom listed as Andrea Marie, refuses to follow the ad litem's recommendation, saying it's not a court order until the court tells her to do it. She won't be doing it. And that's the only thing that we have to report today for status, Your Honor.
Okay. Andrea Marie.
Yes, Your Honor. Andrea Marie, present.
Okay. I thought I had already indicated the last time that I was here how it is that I do these cases, but just to refresh your memory, I don't play games, so I don't expect you all to play games, okay? So you're either going to cooperate with the process or it's going to go a little bit more difficult for you. So the ad litem is here to assist the court. And if the ad litem is making a recommendation, then the recommendation is going to be followed because she has an obligation to look out for what's in the best interest of the child. Yes. So whatever she recommended for the drop off and the pickup is going to be followed. Do you understand me?
Yes, I do, Your Honor. I had a question as far as that, Your Honor. I have been in contact with both sides in the same email with attorney Lucia Thompson as well as the ad litem. And there was no recommendation as far as in the email. That was just the recommendation that we were in communication with for last school year. I know Ms. Thompson, attorney Lucia Thompson did let me know as far as that was the recommendation for, the Ms. Alvarado, but I did not receive that in writing, even through email with, I was unaware of that, of the recommendation. I'm not saying I'm not going to be in compliance with that. It's just that I wanted to have it in writing that was her recommendation as far as being let know of the change.
Okay, you're still representing yourself?
Yes, Your Honor.
Okay. Well, you're going to be held to the standard of an attorney.
Okay.
And
Judge, I'm so sorry, if I may, I have an email dated 8/27, 6:55 in the afternoon where Ms. Trevino acknowledges that the recommendation is there from Mrs. Alvarado. She says there are no current standing temporary orders. With this being addressed, I will only be following court orders or something signed by the court. And she knows of the recommendation, and the recommendation is below where Ms. Alvarado is saying, unfortunately, she's sick. But if this is the recommendation that she's making, I guess it's just, I wish we had a case where these parties were able to co-parent and not do it, but we just don't.
Your Honor, Miss Alvarado did not send the email that she was the one saying she was sick. That was with Miss Lucia Thompson's secretary, Miss Annette Rodriguez.
Okay, that's not the issue here. I know what Miss Alvarado's situation is. And
Okay.
it's not for me to put on the record. So
Yes.
don't worry about Miss Alvarado. You need to worry about yourself. And so you also need to worry about what it is that you need to do. So the pickup and the drop off is set. It sounds like you all are all on the same page of where that's going to be. Now let's make it happen, okay?
Yes, Judge.
Okay. So do you need to submit any modified orders, Ms. Thompson?
I'll submit it based on Ms. Alvarado's recommendation, yes.
Okay, normally I would have everyone sign off, but go ahead and just send it for my signature, being that
Okay.
I've already given the admonishment on the record.
Okay, Judge. And may we have a final hearing date or a DCC? I'm not sure how the court goes about that.
Okay, so how much time do you need?
We're ready, I guess, once Ms. Alvarado's feeling ready, so maybe in 30 days, just to be extra safe.
Okay. Let's go ahead and do it for October the 6th at 9:30, and that's provided if everything is agreed to. If it's not agreed to, then I do need to move you to the contested docket.
Okay, Judge.
Okay?
Yes, Judge. We'll see if we can get an agreement before then, and if not, then we'll get it moved.
Okay. Thank
Can I
you.
be excused, Your Honor?
Yes, ma'am, you may be
Thank you.
excused.
Likewise, Your Honor. Thank you.
Thank you. Okay. Let me see, Ms. Rivera, I don't understand, did Mr. Acevedo need to be taken up now? Is he still on?
He's not on, they're in person in a
Oh,
family
okay,
setting, yes, ma'am.
okay, got it. All right, Attorney Lucy Williamson?
Good afternoon, Your Honor, Lucy, or good morning, Lucy Williamson here. Your Honor, I apologize, I don't know what number on the docket I am, but it is 70, F7172-15-9.
Okay, in the interest of Gabriel Contreras?
That's correct, Your Honor. I am out of town and was unable to meet with my client. I know the parties have been working out on the visit, so I'm asking for some additional time, Your Honor. It should be an agreement.
Okay, and what is the respondent's name?
Your Honor, I do not-
Antonio Contreras, right?
Yes, yes.
Okay, Mr. Contreras, please remove your cap.
Oh, sorry about it.
Okay, yes, okay, so Mr. Contreras, Ms. Williamson, I'm not sure, okay, Ms. Williamson is unavailable because she's out of town. So we're going to have to reset this hearing. And how much time are you asking for, Ms. Williamson?
Your Honor, I don't foresee needing more than 30 days.
Okay, are you all available October 6th at 9:30?
Yes, Your Honor.
Okay, Mr. Contreras, I need for you to be back on October the 6th at 9:30.
All right, Your Honor. Thank you.
Okay, all right.
Thank you, Your Honor. I have nothing further if I could be excused.
Yes, you may.
Thank you.
Thank you. Attorney Carlos Quintana?
Your Honor, good morning. I'm number 20 on your docket.
Okay, F0271-21-9 in the interest of a minor child.
Yes, Your Honor, real quickly. I did file a motion for continuance in this case because we have not been able to serve the biological father in this case. And we have made efforts. Matter of fact, we need to file a motion so that the court can appoint an ad litem to make his findings as to whether or not he's able to locate the biological father. Otherwise, we can't proceed.
Okay. Go ahead and also file your motion for substitution of service, asking for what type of service you'd like, such as a citation by publication. And then you can also file your order appointing an ad litem for the absent party.
Yes, Your Honor.
And when you file your motion for substitution, we'll just do the order setting hearing and we'll get you set as soon as possible so you can keep on with your case.
I'll do that very well.
Okay, do you need about 2 weeks to do that, Mr. Quintana?
If you can give me 3 weeks, Your Honor, I have a series of things going on and I need more time.
Okay, let me go ahead and just set a tickler for September 24th, just so I don't lose track of the case, okay?
Thank you, Your Honor.
All right, anything else, sir?
Nothing further.
Okay, have a good day. Okay, Attorney Jose Luis Flores.
Good morning, Your Honor.
Good morning.
I'm here on number 5 on the court's docket, Your Honor, civil docket.
F1908-21-9 in the matter of the marriage of Angelita Guerrero and Jose Espinosa.
Yes, Your Honor. We're here to prove up the divorce. It's an agreed divorce.
Okay, and is Mr. Espinosa here or did he sign off on the decree?
I see he filed a waiver, Your Honor, but it's my understanding that he's going to appear. I don't know whether he's on. I see my client. She's on, Ms. Guerrero, but I don't know
Okay.
whether he's on.
Is your
Yes,
client,
he's here.
is he
He's
with you
Yes.
in the same room?
No, he's in the living room.
Okay, does he have his own Zoom on right now?
Yes.
Okay, do you know what name he's under?
He's wearing a hold on, let me check. He's wearing a
red shirt?
Yeah.
Okay, so Mr. Espinosa, can you hear me?
Yeah.
I
hear
think
you.
he's frozen.
Your Honor, my understanding is he needs an interpreter, Your Honor.
Okay, the only thing I'm gonna ask you is for you to please read the agreement into the record slowly so that my translator can translate in pieces, okay?
Yes, Your
And
Honor.
do you have a divorce decree that's been signed by both the parties?
No, Your Honor, I have it ready.
Okay.
But it's my understanding that they both have agreed to the stipulations on the divorce decree, Your Honor.
Okay, that's fine, but I do need for him to sign off on it either way, okay?
We will, Your Honor.
Okay, Ms. Guerrero, can you please raise your right hand? Do you swear that the testimony that you are about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Okay, Mr. Espinosa. Ms. Castaneda, can you please have him raise his right hand and administer the oath?
Mr. Espinosa, por favor, levante su mano derecha. Jura que el testimonio que va a dar es la verdad, toda la verdad y nada más que la verdad.
Lo juro.
I swear.
Okay, tell him to lower his hand.
Puede bajar su mano.
Okay, Mr. Flores, you can continue with questioning your client, Ms. Guerrero.
Could you please state your name for the record?
Angelita Guerrero.
And Ms. Guerrero, are you the petitioner in this divorce?
Yes.
And have you been living in Texas for the last 6 months?
Yes.
And have you been living in Hidalgo County for the last 90 days?
Yes.
And were you and Mr. Espinosa married on July the 25th, 2016?
Yes.
And you both separated sometime in January of this year, is that correct?
Yes.
And has your marriage become insupportable?
Yes.
Is there any chance of reconciliation?
No.
Are there any children born or adopted during the marriage?
No.
Are you expecting any children?
No.
And as far as the division of the estate, you and Mr. Espinosa have entered into an agreement. Is that correct?
Yes. Yes.
And there are 2 homes. One at 114 Rancho del Rey in Mission, And another home, it's 5005 South 33rd Street in McAllen.
Okay,
Is
hold
that-
on. Let Ms. Castañeda, let Mr. Espinosa know that we're doing the division of property and that you're asserting that there are two homes, okay?
Mr. Espinosa, ahorita están haciendo la división de las propiedades y están avisando que hay dos propiedades, ¿correcto?
Correcto.
Correct.
Okay, and can you give them the address of those homes? Did you get those, Ms. Castañeda?
I only have the 5005 South 33rd Street in McAllen.
Okay, what's the first address, Mr. Flores?
It's 114 Rancho del Rey in Mission.
Ok, las propiedades una es 114 Rancho del Rey en Mission y la segunda es 5005 Sur 33 en McAllen, ¿correcto?
Correcto.
Correct.
Okay, you can continue.
And Ms. Guerrero, these two properties, you and Mr. Espinosa have agreed that you will, he's leaving you those two homes. Is that correct?
Yes.
Mr. Espinosa, las dos propiedades se van a quedar con la señora Angelita Guerrero?
Correcto.
Correct.
Okay, continue, Mr. Flores.
Ms. Guerrero, there's also a business by the name of Oriental Kitchen LLC. Is that correct?
Yes.
And that business, you own 51% and Mr. Espinosa owns 49%. Is that correct?
Yes.
Mr.
And
Espinosa.
Okay, go ahead, Ms. Castañeda.
Mr. Espinosa, también hay un negocio, Oriental Kitchen, que la señora tiene 51% y usted tiene 49%.
Correcto.
That's correct.
And Ms. Guerrero, it's your agreement that you will own the company Oriental Kitchen LLC 100%. Is that correct?
Yes.
Y es un acuerdo, Mr. Espinosa, que la señora Guerrero se va a quedar con el 100% de Oriental Kitchen.
Correcto.
That's correct.
And Ms. Guerrero, in exchange for the two homes and the business, you have agreed to pay Mr. Espinosa $17,500. Is that correct?
Yes.
Mr. Espinosa, y en cambio, usted, por las propiedades y el negocio, la señora Guerrero le va a pagar a usted $17,000, $17,500, ¿correcto? That's correct.
And Ms. Guerrero, you have already paid the $17,500 to Mr. Espinosa. Is that correct?
Yes.
Mr. Espinosa, y la señora ya le pagó los $17,500, ¿correcto?
Correcto.
Correct.
Ms. Guerrero, Mr. Espinosa owns a 2021 Toyota Tacoma. And you're asking the court to award that vehicle to Mr. Espinosa. Is that correct?
Yes.
Mr. Espinosa, usted es propietario de una 2021 Toyota Tacoma que se va a quedar con usted, ¿correcto?
Sí.
Yes.
And Ms. Guerrero, are you asking the court that any personal effects, household furnishings, household items that are in your possession, you're asking the court to award them to you?
Yes.
Mr. Espinosa, las cosas, efectos personales, artículos para el hogar se van a quedar con la señora.
Sí, correcto.
Yes, correct.
And as far as the personal effects and household items that are in the possession of Mr. Espinosa, you're asking the court to award those to Mr. Espinosa. Is that correct, Ms. Guerrero?
Yes.
Y tocante las cosas, efectos personales que están en su posición se van a quedar con usted, ¿correcto, Mr. Espinosa?
Correcto.
Correct.
And Ms. Guerrero, are you asking the court to grant you this divorce?
Yes.
Mr. Espinosa, la señora Guerrero está pidiéndole a la corte el divorcio.
Correcto.
Correct.
As a witness, Your Honor.
Okay, I don't think he has any questions of her. All right, then the court will accept the agreement as read into the record that'll be set forth in further detail in a divorce decree to be submitted by the parties. And I'm gonna ask for that to be submitted by September the 10th. And that does need to be signed off by both parties. Ms. Castañeda, please let Mr. Espinosa know that he will be contacted by Mr. Flores' office to sign the divorce decree. And he has, if he can please sign it when they call him. If he refuses to sign it, then Mr. Espinosa can still file a motion for entry.
Mr. Espinosa, la oficina del señor Flores se va a contactar con usted para que firme el decreto. Por favor, se mantiene en contacto con ellos. Si usted no lo firma, la oficina del señor Flores puede meter una moción para que la corte firme el decreto.
Ok, correcto.
Okay.
Okay. Anything else, Mr. Flores?
No, Your Honor, that's all I have this morning, Your Honor.
Okay, then you and your client may be excused. Ms. Castañeda, please let Mr. Espinosa know that he is also excused.
Mr. Espinosa, se puede retirar.
Thank you.
Thank you, Your Honor.
Okay, have a good day. Okay, Attorney Hector
Likewise, thank
Garcia.
you.
Good morning, Your Honor. Hector Garcia here for the plaintiff, Jenny De Leon. I believe it's number 1 on your docket, CL 15-4199-1, but now I understand it's County Court number 9. And we're here for status hearing.
In your honor, Rick Zuniga on behalf of the defendant.
Okay, it's number 31 on the court's docket. Okay, and what is the announcement?
Judge, I think we just need a trial date. This case was filed in 2015. We've had trial dates that did not go forward. Discovery was initially performed. Mediation's been completed. At some point, the court, the prior court, County Court 7, allowed for some additional limited discovery. There were never any requests made in the time period that the court allowed for that. So those depositions did not take place. And now, from our perspective, from the defense perspective, let's show up and try the case. I understand that not going to be any jury trial soon, but that's the current status of the case.
Okay, so then you all have concluded the discovery process.
Your Honor, the plaintiffs disagree. The docket control conference that was in place expired because of the Supreme Court emergency orders that started back in March of 2020 and at least continued to September 30th. And for those reasons, some of the depositions were not taken of defendant. And we basically need a DCC. And you look at those orders, Your Honor, they suspended any proceedings pursuant to any court order. So the plaintiffs still need to take the depositions of the rep and about 2 or 3 employees or ex-employees. So we would need subpoenas to depose them and locate them. And in addition to that, we were not able to do it. And then you also had the governor's shelter-in-place orders. So there was no way that we could have conducted those depots pursuant to the Texas Supreme Court emergency orders that were in place and the governor's orders regarding shelter in place.
Your Honor, if I may, this case was set for DWOP for the first time in 2017. It was set for trial for the first time in 2018. I understand that Mr. Garcia was not handling this case at the time, but that was the first setting. There's been additional settings for trial. There's been additional settings for DWOP. This is not something that's a pandemic case that was, this case was filed in 2015. There has been ample opportunity for discovery, and it just hasn't occurred. Depositions have continued to occur during the pandemic, but the first and second discovery periods closed before the pandemic even started. If Mr. Garcia would like to depose, would like to take testimony from additional individuals, he's welcome to do that with trial subpoenas. He's welcome to do that at the time of trial. But I don't see any reason to reopen discovery after it's been closed multiple times and then graciously extended again by Judge Valdez after the final one closed. And again, that final order from Judge Valdez was very limited in its scope and extension. It did not reopen. It did not set a new DCC. The court declined to do that despite Mr. Garcia's request. And I'd ask this court to keep in line with the ruling from Judge Valdez so that we're all that's left at this point is to go to trial.
Your Honor, in response to that, what the County Court number 7 did with the Office of Bobby Garcia was allowed it to conduct those depots last year, but because of the COVID orders from the Supreme Court and the governor's orders, they were not done. And that's what we're asking today, for us to be able to conduct those depots, which is about 3 or 4 depots. Now, I understand from the defendant that those employees no longer work there. So we're gonna need to locate and subpoena them. And we also need the state rep. And we would like to conduct those depots. It wasn't because of us. It was because of the Texas Supreme Court emergency orders from March, at least to September 30th. So that's why those orders expired as regarding doing the depositions of those particular deponents.
Judge, I anticipate if Mr. Garcia wants to take depots, he'd probably do them via Zoom, which is the exact same way we would have been doing them in 2019 when this initial request was made. And I think that looks like it was done, I'm trying to done really early in 2000.
The thing is what it sounds like to me is if you all are, first of all, in disagreement as to whether the discovery period is open or closed. So I'm anticipating somebody has to file a motion to clarify whether or not it's open or closed, and that's going to be your first hurdle, because if you send any notices for depots, they'll quash them. I mean, you don't have to answer that on the record, Mr. Zuniga. I'm just making an assumption that you're not going to make them available, because he's already stated that if you want them, you can get them at the time of trial. What I will say is this is obviously one of my older cases, so it'll be going first, you know, really, really up at the front. And when I say that, we're going to make a list of all those that are going to go to trial. We're starting with the oldest to the newest that say that they're ready for trial, which is why I made that announcement the last time, that if you're announcing ready for trial, I mean, I'm going to take you at your word, obviously, is that you're ready for trial. And then we're going to move forward, because next year is going to be very busy with the jury panels, and we'll probably be in trial a lot. So, you know, right now, since we're here for status, now we know that you all are not in agreement with whether or not your discovery period is opened or closed. So, I mean, you guys need to get that figured out, because, and if you're going to notice these depots, then notice them, even if it means that you have to have a hearing on them being quashed. But you got to get, I mean, we have to make some movement because it's a 2015 case. So, go ahead.
Those were some of the arguments that were made back in, I believe it was May for the status hearing, that all we wanted to do is take those depots and I'm just informing the court that whatever orders were in place to take those depots, it expired, they were canceled because of the Texas emergency orders that were in place, Texas Supreme Court and the government.
Well, Mr. Garcia, the thing is that back in May, you all made that, if you made that announcement, that was 3 months ago, those depositions could have been conducted. I mean, there's plenty of depositions that have been conducted throughout the pandemic that were via Zoom. I'm not sure what reasoning, well, it sounds, I'll strike that. It sounds to me that the reasoning that you're using is you argued shelter in place and you argued that there was an executive order by the governor. However, it didn't stop other people from doing their depositions. So I don't know what you all want to work out. I don't know if you want to go ahead and do your, notice your depot so that we can get you in here, because I'm sure they're going to oppose it. I just need some movement on this. I'm not going to tell you how to work your case on either side, but I'm just assuming that it's going to be very contentious before we even get to the trial. So if that's going to be the case, then let's get it going so that I can put you on my docket, because holidays are going to come up and that's literally around the corner. So whatever you all want to do with respect to this case, as far as pushing forward with it and defending, on the defense side, let's just do it. And you let me worry about making the decisions on whatever it is that you guys bring forward, because I think I'm proving that I'm not afraid to make those decisions. All right. So I said I wanted to move my docket. I am very much wanting to do that. I don't want cases on here that don't need to be on here. I anticipate that those trial slots are going to be filling up pretty quickly, because I anticipate that I'll probably be in trial pretty much every week next year as soon as we get the clearance. So you gentlemen talk, see what you all need to do. If you want to set motions, go ahead and set them. We'll get them set for you. But we are not going to resolve the issue of discovery right now. And I think that's evident. So what I'm going to do is, I need to know what you all are going to do as far as moving forward with this. I'm going to give you all 30 days to discuss it and see how you want to proceed. And we'll come back on October the 6th at 9:30. Between now and then, feel free to, of course, file any motions that you need to. But we'll just keep it going and let's see what happens. Okay.
Your Honor, just for the record, we tried talking, but he's insistent on not taking the depots. So that's why we haven't moved forward at all. So we'll be here in 30 days again, but we'll follow our proper motions in the meantime. I mean, I'll try again to talk to him, but like talking to the wall. Thank you.
No, we don't need those sidebar comments, but it's
I
called
apologize.
advocating for both of your sides. That's what it is.
Thank
Strong
you.
convictions. So it's I have just go ahead and talk to each other, extend professional courtesies. And I understand sometimes you just can't budge and you want to go to trial, and we'll just take it from there. So, but we'll see you all on October the 6th at 9:30. Okay.
Thank you, Your Honor.
All right. So,
Stay safe.
Likewise, Mr. McLaughlin, you had a quick announcement. Is that correct?
Yes, Your Honor, it's for a default judgment
Okay.
on number 43 on the docket.
CO 173397-I Jefferson Capital Systems versus Maria Honorato. That's Honorato. And Mr. Damian, can you please call out her name 3 times?
Yes, ma'am. Maria M. Honorato. Maria Honorato. Maria Honorato.
Okay, the name not being called out, being called out 3 times and no response, you may proceed.
Yes, Your Honor. In this case, we believe that Ms. Honorato had opened up a MetaBank credit account. It was opened on June 15th of 2011. She made her last payment on April 1st, 2014. Off the case.
Mr. McLaughlin, I'm losing you. Your audio is sounding robotic.
Okay, I'm sorry. Her last payment was April of 2014. The case was filed in August of 2017 within this 4-year statute of limitations. The case was served in December of 17. A motion for default judgment and proposed order was filed in January of 2019. We are seeking damages in the amount of $1,095, which was the amount that was closed and charged off. And we would ask the court to take notice of the non-military declaration, certificate of last known address, and business records affidavit that were filed with the motion for default judgment and issue judgment for the plaintiff.
Okay, the court will take judicial notice of all the documents in the court's file, specifically that service was properly done and no answer was on file, and will grant the relief requested by the plaintiff. Do you have?
Thank you, Your Honor.
Do you have an order on file?
I believe that there was one filed on in January of 2019, but I will send another one just in case.
Okay, well, either way, if that one is if it's correct, I'll have my staff ask that one to be forwarded to me.
Thank you, Your Honor. May I be excused?
Yes.
You have a good day.
Okay, likewise. Okay, Attorney Juan Guerra. Mr. Guerra?
Yes, ma'am. Good morning.
Good morning, sir.
Side, trying to get me off the. And I apologize, Your Honor. I'm also on vacation. I'm in Cancun.
Oh my goodness. Okay. Well, what number are you on the court stop? Do you happen to know, sir?
I only have the cost number CL 203084. I don't know what the number is, Your Honor.
Oh, okay. It's the Trinity Life Insurance Company versus Leslie Gomez et al. That's number 19.
Yes, I think Mr. Mike Schroeder is, I thought I saw him there.
I'm here, Your Honor. Good morning.
Good morning, sir. Okay. Did Mr. Guerra, did you file a motion for continuance by any chance?
No, but it's a summary judgment, Your Honor. I filed my answer, and I was going to suggest, obviously, I'm going to go ahead and just do it by submission. I've answered it's an eviction, Your Honor. Usually, what happens on an eviction, it's a foreclosure. Trinity foreclosed on my client. And when it's the same person, we don't have an innocent purchaser. And what I find that when it's the bank or the same person that are financing, there's a good chance of when we go to mediation that it gets resolved. But I don't know if opposing counsel would like to consider that before the court makes a decision on the summary judgment. I did file an answer on his motion for summary judgment, but this case is not being mediated. And it is the same bank that foreclosed, and it's the same bank that my client had previously had a mortgage with. So I don't know what Mr. opposing counsel's position is, Your Honor.
Okay, so Mr. Schroeder, do you want to move forward with this, or do you want to go ahead and go to mediation first?
Your Honor, I would prefer to move forward with this. I've tried to work this out with defendant's counsel and have been unable to do that. As the court is aware, under Chapter 24 of the Property Code, the only issue in this case is right to possession. We have filed with our motion for summary judgment a business records affidavit attaching the deed of trust, the substitute trustee's deed, and the notice to vacate under Texas Rule of Evidence 902, subsection 10. Those documents prove that my client is the owner of the property and is entitled to possession of the property under paragraph 12 of the deed of trust. The language there states that any occupants of the property after foreclosure are tenants at sufferance, and under Texas law, they may be removed by a writ of possession, Your Honor. I've seen no response to that affidavit. We also filed a motion for judicial notice of the same documents as adjudicative facts under Texas Rules of Evidence 2001, B and C. The response.
Okay, I'm sorry. What I'm gonna do is I have to take a quick 5-minute break and we're off the record. We'll be right back.
Thank you.
Okay, so let me just make sure that my court reporter's ready.
Yes, Judge, ready.
Okay, so we're back on the record. So it seems like you all are gonna have some contested issues, and I'll be honest, right now, I don't have the opportunity to hear something long because I still have two parties that are waiting that I have to confer with them in chambers. So the reality of this, Mr. Schroeder, is that I do need to reset it myself. So I'm gonna have you all come back in 2 weeks.
Thank
So,
you, Your Honor.
I'm gonna have you all come back on September the 15th at 11 a.m.
Your Honor, I have a conflict on the 15th. I'm in Collin County Court for an
Okay.
in-person hearing.
The 29th? Does that work?
Yes, I'm good on the 29th, Your Honor.
Okay, then
And so
we'll see
and this matter will be taken up at that time.
all of it. All of your pending motions.
Thank you, Your Honor.
And that'll be at 11.
Thank you, Your Honor.
Okay,
May I be excused, Your Honor?
you certainly may. Thank you.
have a
Y'all
gr-
be safe.
You too.
Stay safe, Your Honor. Bye.
Okay. Let me see, Mr. Espinosa, other than the case that you have with Mr. Ramirez, did you have something on this docket?
No, Judge.
Okay, just hold on for me, please.
Yes.
Okay, and I do have the Aguirre Law Group on and Mr. Gutierrez on.
Good morning, Your Honor. Javier Aguirre for Mr. Leonel Villafranca.
Morning, Your Honor. Dallas Gutierrez here for Miss Andrea Castañeda.
Okay, so, and gentlemen, what are you requesting this morning?
Your Honor, this is a agreed divorce, and if the court allows it, we can prove it up this morning.
Okay. Okay, I'm not sure why I thought this was contested. Okay, so Leonel Villafranca, is he present?
Yes,
Your Honor.
Okay, and how about Andrea Castañeda?
Yes, ma'am. Yes, Your Honor.
Okay, so will you both raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Mr. Villafranca?
Yes, ma'am. Yes, Your Honor.
Ms. Castañeda?
Yes, Your Honor.
Okay, and who will be proving who will be proving up the agreement?
Your Honor, I can do that if Mr. Dallas Gutierrez is okay with that.
Yes, Your Honor. That is.
Okay, Mr. Aguirre, go ahead and ask the prove up questions of your client, and then when it gets to the agreement part, you can just read that agreement into the record in its totality, and then we can just ask each party if that's their agreement.
Thank you, Your Honor.
Okay, you may proceed.
Thank you. Mr. Villafranca, please state your name for the record.
Leonel Villafranca.
Mr. Villafranca, did you file this divorce prior to filing this divorce? You were living in Hidalgo County, Texas, for the past 6 months?
Yes.
Okay. And were you married on or about December 8th, 2019 to Miss Andrea Castañeda?
Yes.
Okay. And you're filing for this, and you were separated on or about February 2021, correct?
Yes.
Okay. And you're filing for this divorce because the marriage has become insupportable because of discord or conflict of personalities between yourself and Miss Castañeda,
Yes.
and it destroys the legitimate ends of the marriage relationship between yourself and her. Is that correct?
Correct.
And there's no reasonable expectation of reconciliation.
No.
Okay. And you don't live together right now.
No.
There is one child of the marriage, correct?
Yes, correct.
What's her name?
Lucinda Isabela Villafranca.
Okay. Do you know if Miss Castañeda is pregnant right now?
No.
Okay.
She's not.
And that's the only child you all have, correct?
Yes.
Okay. And you don't have community property, is that true?
True.
And there is no debts that are community either, correct?
Correct.
So what you have in your possession is yours, what she has in her possession is hers, correct?
Correct.
And any debts in your name are yours, any debts in her names are hers.
Correct.
And as an agreement, you and her are going to be joint managing conservators of the child.
Correct.
And it will be standard visitations.
Correct.
And child support will be based on the guidelines at a minimum wage rate.
Correct.
Okay. And you're asking for this divorce, correct?
Correct.
Pass the witness, Your Honor.
Okay, any questions, Mr. Gutierrez and Mr. Villafranca?
No questions for Mr. Villafranca, Your Honor.
Okay, any of Ms. Castañeda?
Just 3 questions, Your Honor.
Okay, Ms. Castañeda, just please listen to what your attorney is asking you.
Ms. Castañeda, did you hear all the questions asked of Mr. Villafranca?
Yes, sir.
And are you in agreement with the answers?
Yes, sir.
Are you currently pregnant?
No, sir.
Okay, no further questions, Your Honor.
Okay, then the court will approve the agreement as read into the record and grant the divorce as requested today. This will be set forth in a final decree of divorce that'll have all the details of what you have agreed to today. So I do need for the attorneys and the parties to sign off on that decree before it is e-filed. How much time do you need, gentlemen?
Your Honor, if I can have 10 days just so we can circulate it around.
Okay, I'm just gonna set a tickler for September the 24th, just to make sure that it's been submitted.
Thank you, Your Honor.
Thank you, Your Honor.
Okay, anything else?
That's it. May we be excused?
You certainly may.
Thank you, ma'am.
May we be
Okay,
excused?
thank you. Yes, everyone is excused on this case. Okay, Roland Quintana.
Yes, Your Honor.
Okay, what case are you here on?
I am here on number 14 on the court's docket. It's a motion for summary judgment, Your Honor.
Okay.
Good morning, Your Honor. Eric Holguin for the defendant. I'm going to be taking over this case.
Okay, Eric, good morning.
Good morning, Judge.
Okay, how long are you all gonna need for this contested motion?
I'll take about 15, 20 minutes, Your Honor.
Okay. I do have 2 other pending contested matters. Let me see. I apologize. If I would have known that it was gonna be at that length, I would have let you know a reset date sooner. I'm gonna need for you all to come back on September the 15th at 11.
Thank you, Judge.
Okay, I apologize, gentlemen.
Mr. Quintana, I'll be giving you a call. I'll be taking over this case and we'll see if we can resolve any of the outstanding issues.
Okay.
Thank you, sir.
Thank you.
Okay, thank you, gentlemen. I appreciate it. Okay, Ms. Hernandez, which case are you here on? I'm sorry. Oh, you're saying, okay. I think it's number 9 on the court's docket. Ms. Rivera, is this the case? Ms. Olivares and Mr. Acevedo are in a contested matter, is that correct?
Yes, ma'am.
Okay. Ms. Hernandez, I apologize, but we received a notice from another court that both of those parties are actually physically in a contested hearing in that court. And so they were not going to be freed up to be on this Zoom hearing. So we're giving a reset date of October 6th at 9:30.
Thank you, Your Honor. May I be excused?
You certainly may.
Have a good day.
Thank you. Likewise. Okay, San Juana Maldonado, what case are you here on? San Juana Maldonado?
Aquí estoy, buenos días.
Okay, Ms. Castaneda, after what case she's here on?
Ms. Maldonado, ¿en qué caso ha estado usted aquí?
Perdón, está un poquito bajo el volumen.
¿En qué caso está usted presente aquí?
En divorcio.
On a divorce.
Okay, I do see she's number 7 on the court's docket. Ask her if she's had contact with her husband, Victor Carranza.
Ms. Maldonado, ¿ha tenido usted contacto con el señor Víctor Carranza?
Si tengo contacto,
Correcto.
sí.
Yes.
Was he going to be present today?
¿El señor Carranza iba a estar presente hoy?
Sí.
Yes.
Okay, Mr. Damian, please call out the name 3 times.
Victor Carranza, Victor Carranza, Victor Carranza.
Okay, the name has been called out 3 times and no response. Let me see. Okay, I do see that her husband signed the divorce decree. Let me just look at the divorce decree very quickly and see if it's correct. Mr. Acevedo, can you hear me? Mr. Acevedo, you're on mute. Mr. Acevedo, we were notified that you're in a contested hearing, so we reset your case to October the 6th at 9:30, sir.
Thank you, Your Honor. I apologize, Your Honor, but I did try logging in. I was actually outside your courtroom, and I wasn't aware that you all were not were there personally. But Ms. Olivares is actually right here and right next to me, and we actually tried walking over to your courtroom.
That's fine. Just go ahead and give her the date, and we've already notified the AG's office as well.
Your Honor, and actually, I think Ms. Olivares and I have reached an agreement. So hopefully we'll have that filed before October 6th.
Okay. All right.
Thank you, Your Honor.
Okay, thank you. You certainly may.
Bella.
Ms. Castañeda, please let Ms. Maldonado know that her divorce decree is incorrect.
Ms. Maldonado, su decreto del divorcio está incorrecto.
Maldonado know that her divorce decree is incorrect. Okay, and she does need to correct that before she can proceed with her divorce.
Y necesita corregirlo antes de proceder con su divorcio.
¿Perdón?
Ms. Maldonado, ¿me escucha?
No, no le escuché, disculpe.
Su decreto está incorrecto y necesita corregirlo antes de proceder.
So you can ask her how much time does she need to correct that decree.
¿Cuánto tiempo necesita para corregirlo?
Pues, un día.
A day?
Sí. ¿En qué parte está incorrecto?
What part is it incorrect?
I can't give her any kind of advice as to what to correct. She's going to have to review it on her own or seek legal counsel to help her with it.
No puedo darle consejo de tocarte qué parte está incorrecta. Va a tener que mirarlo usted o agarrar con el consejo de un abogado.
Sí.
Yes.
Okay, have her return on September 29th at 9:30.
Okay. Su próxima corte va a ser el 29 de septiembre a las 9:30 de la mañana.
Perdón, ¿me podría repetir el día?
Septiembre 29 a las 9:30 de la mañana.
Septiembre 29. Una pregunta.
I have a question.
Las visitas las podría suspender por el momento a causa porque no tiene un lugar donde tener o cuidar o dormir a los niños.
He does not have a place to stay or take care of the children.
Okay, does she have any orders in place from the Attorney General's office?
¿Tiene usted alguna orden de la oficina del AG's office, de la oficina?
Tenemos el child support establecido.
We have
Que
the
las
child support
visitas
established.
que las
Okay,
visitas van a ser cada 15 días.
That the visits are every 15 days.
okay, that is not in here, so if she has another case number, she needs to give it to you. Ask her if it's there, if she has it with her.
Okay. ¿Tiene usted el número de la orden de la manutención porque no está en esta orden?
Sí tengo sí lo tengo, sí lo
Ask
tengo.
her for the cause number.
¿Me puede dar el número del caso?
Sí. Sí, a ver, denme un momento. Ok, el caso dice F, la letra F, número 2554191. O dice caso número o dice OAG número también.
Okay, I have F255419I and I also have an OAG number.
Okay, I found it. Okay, because she has cause number F-2554-19-1, she now needs to file a motion to consolidate that into this proceeding.
Ms. Maldonado, porque tiene ese número del caso, tiene que consolidarlo a este número que tiene ahorita.
And I
El
can't
número
tell-
de este caso lo tengo que consolidar a este
Correcto.
caso.
And I can't tell her how to do that.
Y yo no puedo decirle cómo lo haga.
Ok,
So I'm giving her till September the 29th to get that filed, the motion to consolidate plus the order granting and the order
Yes.
setting hearing.
Tiene hasta septiembre 29 para meter la orden de consolidar el caso y también la orden para la cita.
And
Okay.
she has to correct that divorce decree.
Y tiene que corregir el decreto.
muy bien. Muchas gracias.
Okay, thank you.
Okay, so that'll be all. Okay, Mr. Is it Dominic Violante? What case are you here on, sir?
Good morning, ma'am. If you can hear me all right, I am number 4 on your docket this morning, case number F0827208. I'm sorry, 209.
Okay, sir, and do you have contact with your wife, San Juanita Guerra?
Yes, she and I spoke last week, actually, in person with my son present as well. Well, our son, he's 19 years old.
Okay, so is there any minor child in this case?
No, ma'am, there's no minor children and there is no joint or community property or real estate.
Okay, so let me look at your divorce decree. Okay, so Ms. Guerra did sign this.
Yes, ma'am.
Okay. And let me just check her waiver of service. Okay, sir, you can raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God, sir?
Yes, ma'am.
Okay, please state your full name for the record.
My full name is Dominic Edward Violante, spelled Violante.
Okay, and you are currently married to San Juanita Guerra, is that correct?
Yes, ma'am.
And at the time that you filed for divorce, you were a domiciliary of the state of Texas for at least 6 months and a resident of Hidalgo County for at least 90 days, is that correct?
Yes, ma'am.
And your wife also executed a waiver of service, is that correct?
Yes, Your Honor.
And that has been properly filed with the court, is that correct?
Yes, ma'am.
And you were married on or about July 5th, 2018, and ceased to live together as husband and wife on or about November 1st, 2018, is that correct?
Yes, Your Honor.
And you're asking the court for a divorce today because your marriage has become insupportable because of discord or conflict of personalities between yourself and your wife that destroys the legitimate ends of the marriage relationship. Is that correct?
Yes, Your Honor.
At this time, is there any reasonable expectation of reconciliation?
No, ma'am.
And although you and your wife do have children of the marriage, you have no minor children at this time together. Is that correct?
Yes, ma'am. That is correct.
Do you know, is your wife expecting a child of this marriage?
No, Your Honor, she is not.
Okay. And so you and your wife have entered into an agreement with respect to the division of property that you accumulated during your marriage. Is that correct?
Yes, Your Honor.
Okay. And so this is in a divorce decree that was signed by both you and your wife. Is that correct?
Yes, ma'am.
And in there, you have set forth property that is going to be awarded to you and property that is going to be awarded to your wife. Is that correct?
Yes, Your Honor.
And you're confirming separate property at 2119 Clayville, that's Clavele Street. Is that correct?
Yes, Your Honor.
And that is in what city, sir?
That is in Mission, Texas.
Okay. And then the property in the marriage is located at 909 North 49th Street. And is that also in Mission?
That is in McAllen, Your Honor. That's the home that we used to live in together.
Okay. And is she still living in that home?
No, she is currently living in 2119 Clavelle. That was her home before our marriage. She retained it. And the home at 909 North 49th has been liquidated. Neither of us own that property anymore.
Okay, so have you divided those proceeds amongst a way that you've agreed to?
Yes, ma'am.
Okay, and so you have also agreed to retirement benefit division?
Yes, Your Honor.
Okay, and you're agreeing to give her 50% of your thrift savings plan, which is $85,000. Is that correct?
Yes, ma'am.
And she'll be responsible for the debt for the 2012 Kia Optima and any charges that she made after November 1st, 2018. Is that correct?
Yes, Your Honor.
Now, the only thing I do not have for you on this decree is what debts are you responsible for?
The Kia was only included because the lien hadn't been recorded as cleared. We paid off that car 3 or 4 years ago.
Okay, so then you'll be responsible for any debts that you incurred after November 1st, 2018?
Yes, ma'am.
Okay, and are there any debts under your name that you need to list? That was during the marriage, or is it you're going to be responsible for any debts that are under your name?
Yes, ma'am. Each of us.
Okay. So then, and you are asking the court for a divorce today, is that correct?
Yes, Your Honor.
Okay. And over the years, you've become familiar with your wife's signature, is that correct?
Yes, Your Honor.
And have you seen the divorce decree that you e-filed with the court?
Yes, Your Honor.
And in that last page, is that your wife, San Juanita Guerra's signature?
I have only the original petition on hand, but I was present with her in person when she signed the waiver and her response. We filed those in person at the courthouse together.
Okay. So then you're asking the court for a divorce today, correct?
Yes, Your Honor.
Okay. then the court will grant the relief as requested in your petition for divorce and as you have testified to today. And will also ask for the divorce decree that has been filed by you and Ms. Guerra to be sent to my queue for my review and signature, okay?
Thank you, Your Honor.
Okay, you are not divorced until I sign it. So don't go do anything yet, okay?
Understood.
Okay, all right, then best of luck to both of you, sir.
Thank you, Your Honor. I have nothing else before the court. I'd ask to be excused.
You certainly may, sir.
Thank you, ma'am. Enjoy the rest of your week.
Likewise. Okay, Bernardo Aguirre. Bernardo Aguirre.
Good morning.
Good morning, sir. What case are you here on?
I am here for F3149-21.9.
Okay, and you're here for a name change?
Yes,
And you did that petition on your own, is that correct?
yes.
Okay. Okay, sir, the only criminal history that I have for you is that that you had an affidavit that was signed by the Hidalgo County Clerk's Office stating that you do not have a criminal history. However, what you are lacking is the criminal history report from the Department of Public Safety. So you have to apply for that with the state of Austin, and then the state of Austin will have that sent to the clerk's office. Now, you also haven't done your fingerprinting yet. Oh, no, yes, you did.
I have done my fingerprinting, yes.
So your fingerprints, so I would get with DPS so that you can have that criminal history report requested. And that needs to be sent to the clerk's office before we can set you for a final hearing, sir.
I was never told that I had to do that with DPS, but okay, I'll get onto that.
Okay, and that's because we need to make sure that just on a statewide search, okay? Okay, I'm gonna give you some time to do that because it does take somewhere between 6 to 8 weeks. Yes, I'm sorry. For DPS to complete it from the time that you submit the request, it takes approximately 6 to 8 weeks. So provided that you do get that back as soon as possible, I'm gonna go ahead and set you for October the 27th at 9:30. And let's see if we've received it by then, okay?
Okay,
Okay, sir. You have a good day.
thank you, you too.
Thank you. Okay, Mr. Paez? Mr. Paez?
Morning, Your Honor.
Okay, sir, what case are you here on?
I am on your number 3 docket. I have getting the number now.
Okay, and is Christy Castillo present?
No,
Okay, it's F0706-20-9, is that correct?
yes, ma'am.
Okay, let me just look it up. And sir, do you all have any minor children together?
Biologically, no, ma'am.
Okay. So there are no children of the marriage, is that correct?
Yes.
Okay. Okay, and I do see a divorce decree that was filed with the court and it has both your signature and her signature.
Yes.
Okay. Okay, sir, will you please raise your right hand? And you're wanting to proceed today?
Yes.
Okay, will you please raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And sir, you're Aleida Natalie Paez?
Yes.
Okay. And you are currently married to Christy Lynn Castillo, is that correct?
Yes, ma'am.
Okay. And you lived in Hidalgo County for at least 90 days at
Yes.
the time of filing?
Yes.
And did you live in Texas for at least 6 months?
Yes.
Okay. And you have no children of the marriage, is that correct? And you were married on or about December 17th, 2014, is that correct?
Yes.
Do you recall the date of your separation?
I believe it was early 2020, if I'm not mistaken.
So on or about what month?
I think, no, it was 2019. It was around January 2019.
Okay. So then the marriage has become insupportable because of discord or conflict of personalities. Is that correct? In other words, you don't get along anymore.
No.
Okay. And this destroys the legitimate ends of the marriage relationship?
Yes.
And at this time, is there any chance of reconciling?
No.
Okay. And you have no community property, is that correct?
Correct.
Okay. And no community debt?
Correct.
Okay. And she does own a 2018 Mazda, but that's her separate property, is that correct? Sir, is that correct? The 2018 Mazda is just her responsibility?
Yes.
Okay. Okay, and you did sign a agreed final decree of divorce that was filed with this court approximately on August the 12th. Is that correct?
Correct.
And you are asking the court to grant the divorce today?
Yes.
Okay. And so I will go ahead and ask for that to be forwarded to my queue, and their divorce will be granted, and the relief that is requested in the divorce decree will also be granted. Okay, anything else?
Nothing further.
Okay, then you may be excused. Have a good day.
You too. Thank you.
Okay, Attorney David Corena, did you have another case, David?
Good morning, Judge.
Because I think someone made an announcement on your behalf earlier.
For me?
Was it yours or am I confusing it? Oh, no,
I
you're
have-
here
I have
with
number-
Savannah.
I have number
Right.
21, yes.
Okay. You know what, I don't know why I thought David Mora was making an announcement on your case, but it was a different case.
Oh, Dan
Okay.
Mora.
Dan, yes. Yeah, I'm hungry.
It's a Monday, Judge.
Yes, F 1320-20-9 in the matter of the marriage of David Lopez Jr. and Stephanie Vallejo. Okay, and I do have both attorneys present. What is the announcement?
Your Honor, this is on my motion for mediation. There was a report that was submitted to the court by Gilda Bowen, and I believe it's something we can work out. However, there's some details that need to be addressed on the conditions that she included in the recommendation. It's a total of 7 different things that we need to address. And the most important one right now, I guess, is whether or not the respondent is now residing in Hidalgo County. And I need some confirmation of that because we had an issue in the month of June. So I need an address and confirmation that she's actually residing in Hidalgo County, because the other conditions are contingent on her actually having a residence, a primary residence for the child here. She was residing in Corpus before, so I can just give the court some background on that. And the recommendation conditions, again, are contingent on her having moved to Hidalgo County. When we were in court on May 26th, at one of the hearings, she had advised the court that she would be moving down within a week of May 26th. My client surrendered the child to her for the month of June and part of July. However, it's our understanding that she was not residing here at the time. So again, I need confirmation of that. There are some other issues, Judge. My client has enrolled the child in speech therapy, which was one of the other conditions. However, the last condition on the recommendation was that the parties split medical expenses. And my client's been trying to collect some of the money for the speech therapy and has been unsuccessful with that. There's also number 6. The recommendation was that no child support would be ordered if the child were to spend equal amount of time with both parents. We haven't worked that out as far as specific times and dates for visitation, if in fact she does move down. So I just thought it'd be simpler if we address this at a mediation instead of to the court. Again, that was just my position. If we could make sure that all these recommendations and conditions are complied with before we prepare and submit a decree. And I thought it would be better addressed at mediation.
Judge, if I may.
Sure.
So, Judge, I have no objection to going to mediation. I think it's, as a mediator, I think it always helps. My issue with this, Judge, is it has been dragging on for some time. What I don't want to happen is that we renegotiate everything, right? Previously we had agreed that whatever Ms. Bowen recommended that we would follow. I have offered up some evidence to Mr. Gorena that my client is in fact residing in Hidalgo County. I will say during the summer months, she did go back and forth between Corpus. She was, trying to transition her life over here. And in any event, the child was not in school anymore. We can assure the court that she is living in Hidalgo County. As to the little terms, I don't have a problem negotiating that whatsoever. I just don't want to turn around and say, now we are renegotiating possession and access separate and apart from what Ms. Bowen's recommendation is, Judge.
Okay, and I understand that. And I think both of you have already made the announcement several times on the record, and I do have that in here that you were going to follow with whatever Ms. Bowen had stated. I would suggest that before going to mediation, set the parameters and make sure, whether it be in a form of a Rule 11 or just have the mediator be very detailed in what's going to be discussed, so that you know what it is that you all will be talking about. But I have faith in both of you all. You all are both very professional attorneys. And I know that if you gave each other your word that this is what you were going to do, I know you're going to stand by it, because that's who you all are. So I'm going to go ahead and I'm going to grant Mr. Gorena's motion for mediation. I'm going to allow you all to set the parameters and work on the parameters that'll be discussed at that time. I'm going to have an order of referral to mediation be sent to both of you, and I'll assign the mediator.
Wonderful, Judge. Thank you.
Okay, anything else, counselors?
That's all, Your Honor.
Okay.
Nothing on my behalf, Judge.
All right, and y'all have a great day.
You too.
Thank you, Judge. Likewise.
Okay, I have a David that's on, just David.
That's my client, Judge.
Oh, okay. You can have, then he's excused. Okay, before I take up Mr. Espinosa and Mr. Ramirez, let me just go through the docket so I can release everybody else. Number 10, any hearing? Anybody call in?
No, Your Honor.
Okay, set that for the drop docket. Number 18.
Number 18, no, Your Honor.
Okay, set that for the drop docket. Number 22, we did have them check in, correct?
That's correct, Judge.
Okay. And then number 30.
Number 30, Judge, I don't have anything.
Okay, well, did we set a show cause or did they ask for a show cause?
Let me double check. Judge, this has been a case that was set originally for February 24th. And the show cause has been reset. When we reset the show cause, that was when we were transitioning from the office to be remote from home. So notice was not given properly, Judge.
For today?
Yes, ma'am.
Okay, just go ahead and give them a new setting and make sure that notice is given properly.
Yes, ma'am.
Okay, that takes care of the rest of the docket. Okay, that concludes this morning's docket. We are now off the record. Okay,